From the heartland of America, it's the Bail in the Midwest podcast, hosted by Shane Rolf. Executive producer, David Stuckman.
Hello and welcome to the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release, and the criminal justice system in the Midwest. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 39 years. Now, I know that this is the Bail in the Midwest podcast, but as regular listeners know, the bail part is more important than the Midwest part. We've talked about bail with people in New York and New Jersey, New Mexico and California, from Florida and Montana, and of course, lots of people right here in the heartland. But today we're going to go about as far from the Midwest as we can get and still be able to talk about bail. The 50th star on the flag, Hawaii. There's a very real concern that the Aloha state is on the verge of saying aloha to bail, but only in the sense of the goodbye, not the hello. James Lindblad is a longtime bail bondsman in Hawaii. He has written a number of articles on bail and the attempts to eliminate it in Hawaii, and is the past president of the Professional Bail Agents of Hawaii, or PBA, which actually has a nice sound to it. James, welcome to the podcast.
Thank you very much. I'm very pleased to be here. Aloha to all.
Well, thank you very much. I love the background there. We should all have that sort of view. But first, before we talk about the Hawaii, let's talk about you. So what I always ask everybody, how did you end up in what I call bail world? Nobody has the same path into this. It seems like we all come from different ways. How did you end up in the bail bond business?
I love to tell this story. I love it. I was one of those kids, didn't know where he was going, didn't know what he was doing. I was attending college. I got a job in the Northeast Youth Service Center in Portland, Oregon. I was attending the University of Portland at the time, and I got school credit. I was working full-time at Western Electric, who was paying the tuition, which was very nice. There I met a fellow who helped me a lot. He got elected across the river in Vancouver, Washington, and he started a program, Pretrial Release. They had a LEAP, L-E-E-P, Law Enforcement Educational Program grant to $1.7 million, and he needed people to interview pretrial defendants for release on bail. I loved it. It was right up my alley. I worked 6 hours, 8 at night to 2 in the morning. I had authority to sign people out on misdemeanors, and then I would do interviews for pretrial felons and make recommendations to the judge the next business day. And of course, we're all out there. Smoking cigarettes was a big deal back then, drinking coffee. At the coffee shop, there's all these bail bondsmen hanging around. And I thought, I didn't like the bail bondsman at all. Let me tell you, I was pretrial release. These guys, I thought, you can't charge money for this. This is not fair, Gee whiz. Well, I quickly learned not quickly, at 2,000 interviews later, I could see pretrial justice was not being served by government. We were targeted with helping the truly needy. Well, guess what we were doing? We were ignoring the truly needy. And I said, this is not working. What are we doing? We're spending all of this money. We're ignoring the targeted market, the truly needy. And I didn't like that. And so I went, talked it up with the bail bondsman, and they said, well, as long as you move out of our town, we'll help you. So they punted me up the road to Seattle, Washington, and I opened a bail bond office up there, where I met my wife, incidentally. My wife was a pretrial release worker, 8 years, King County, Washington. That's Seattle area. And right. Very successful bail bondsman. I could bail people out, mom and dad, brother, sister, employer, third party, none of that two-party stuff where the guy just promises. The judges, the courts, people like that, they don't have the benefit of the three-party. And I could plainly see that people needed help. They didn't want to wait for the judicial decision the next business day. They didn't want to wait over the weekend. Some people preferred to bail out. At any rate, I was born in Honolulu. So after working 4 hard years in Seattle, which I love Seattle, I decided to move back home to Honolulu, where I was born. And there was a fellow bondsperson over here who welcomed me with open arms. He's now passed away, but he picked me up. He got me a condo. He taught me the ropes. The other bondsmen over here were very friendly. There was only 3 of them in the whole state at the time. This is 1980. And I just began, like every other bondsman, just made myself available. I had a big advantage. I understood real estate. I understood how to take collateral on the mainland. That's what we call the other 48 states. I understood letters of credit from the banks. I had training from my father in real estate, so I knew what a trust deed was. I knew what a mortgage was. And there was a lot of people stuck in Hawaii who couldn't get bail collateral because their relatives were parts unknown. We have a very diverse population here. We're not homogenous like some countries where we're all a certain race or things of that nature. There's a lot of people from all over the world here, and they have connections: Canada, Switzerland, England, Japan. And I was able to secure the bonds, and I had enough to sign my own name on the bonds for a long time, and then we sort of morphed over into the licensed insurance agent with the corporate surety. Corporate surety was kind of a big deal. Didn't used to be, but it is a big deal now. Corporate surety, the laws here are corporate surety is adequate and sufficient. They don't have to justify the suretyship because the statute says that if you're a corporate surety, you're deemed acceptable.
So does that get run through the insurance department there? Or,
yes. The DCCA, we have the DOI, Department of Insurance, and I favored all of that. And so the next thing you know, there's a lot of surety companies coming over here, testing the water. Right. You know, they see the fertile soil, and I've said this over and over. They know who I am, and they know that they need to behave themselves. They need to pay their claims. They need to ensure that their agents follow proper protocol. PBUS, if you know anything about PBUS, we have what's called Code of Ethics. So Code of Ethics is very clear. And that's how I got my start. And I
do want to talk about that a little bit more, though. I've not seen anyone come from the pretrial release space, because it sounds like you were basically hired to compete with, or because most of these places that come in to do pretrial, like, well, we need to be able to show them that we can do this. We don't need the bondsman. And a lot of times, unless you have the really true believers, those people last for maybe 2 or 3 years before they become disillusioned with the client base. It's like, yes, I'm not accomplishing. I mean, it's a lot like probation officers. I mean, they don't tend to last for a long time because they come out of college with their sociology degree, and they're going to make the world a better place until the world, slaps them around. And, the clients that they're dealing with don't appreciate their help. They don't want their help, and so then they're like, why am I even doing this? And let me go off and do something else. What did I just spend the last 4 years for? You do get the group, though, that are, what I call true believers, and they'll be in it for the long haul. And they're the people that are out there trying to basically eliminate the bail bond industry on the pretrial, aspect of things. But was that the person that initially hired you? Was that the goal there, or were they just doing like a pilot program? Because you said they got a federal grant, which is always fun, where the feds come in and go, here, we'll give you some money to try and eliminate a business there in your town. Is that still ongoing? I know that that both Portland clearly has, I since they've decriminalized hard drugs, or at least I don't know if they rolled that back yet. They've gone off the deep end. Seattle's getting awfully close. Are they still engaged in that sort of thing?
That's like a 3-part answer. I think that initially it was a righteous, well thought out, meaningful concept. Dr. Richard Pease, Pease, taught us about bail, taught us about pretrial release. We never wanted to offend a bondsperson ever. We wanted to assist and cooperate, work within the system. For instance, on a DUI, they call it DUI in Hawaii. I think they call it DWI in some places, but essentially as if you're driving and drinking, a drunk driving case. Well, we had a 6-hour time limit. We could sign the guys out if they wanted to wait 6 hours to sober up, whether they were or not. If they wanted to bail out, they could pay $35 to a bondsman. The bail was only $250. So there was a very fair balance there. We never wanted to step on any toes. There was never this competing interest, is what I call it. That all came about really much later. And about the time I moved up the road to Seattle, Seattle was much more aggressive. But just to cite an idea there, when my wife was in pretrial release in Seattle, Washington, there was 3 people. 3. They ran it. She'd get there at 3 or 4 in the morning. She'd interview the people from the night before arrest. At 3 o'clock every single day, they'd have arraignment court. And the judge would then make his decision based on the interview. That's how I saw my wife. She's sitting up there next to the judge. She's shuffling the paperwork. She's handing over her interviews, and the judge is making a qualified decision, release or detain, set bail, what have you. So that worked out, at least in my mind, because it was fair and honest. But if you look at it now, it's a little bit different. They scorched earth. Let's get everybody out of here because we have a problem with all they want to do is compare how much it costs per day to keep a person in jail. So they equate their worth and value with how much they're allegedly saving the state or the city or the county. So it became very, very competitive. And then they wanted to expand. So these 3 people that did the work of all those arrests in King County, I don't know how many's there now, but I bet you there's 25 or 50.
Oh yeah, I'm sure. Well, because you've gone from what sounds like what your wife did, and which is something that I think we all get behind, is gather up information so that the court has information to make an informed decision. And that decision could be, this bond's way too low, or this bond's way too high. I mean, you've lived in your home for the last 15 years. This is the only time you've been in trouble. We think you're probably okay to come back to court, but then if you follow up and call and go, that guy's crazy, I don't want him back here. I kicked him out of this address, 10 years ago, and he just uses it. Then the judge can go, well, wait a second, you're not as stable as you've indicated. So now we're going to require you to have some sort of bond, some sort of assurance to get back. But you're right. It has gone away from, we're just simply providing information to the court so the court can make an informed decision to, we are now making recommendations. You, court, you shall give this person a signature bond, or the court has somehow delegated, which I don't think is even legal to a certain extent, their judicial authority to allow you to sign people out and get them out, on your say so. You're not a judicial officer. And in lots of places they've gone ahead of what the statute even allows them to do, and then they come back and go, well, this is what we're doing now, so we just need to change the statute to make what we've been doing the last 10 years legal.
Yes, that is just precisely accurately stated. And the essential dilemma in my view is people don't want to fully argue the issues like we're doing right now. They don't want to have fair and balance. They're pushing an agenda. They have their idea. They've got their data, but they don't have the frontline experience. They don't know about the mother and the father, might want to utilize the jail as a place of last resort where their loved one can get adequate and sufficient help, or maybe just chill out for a day or two.
Right.
But sort of fast forward on all that, when I got going in Hawaii, it was a lot different. And I immediately targeted what we call intake service center here. We had a wonderful intake service center here in Hawaii back in 1980. They'd already had funding. So they would interview people And the district versus the circuit court, that's kind of like municipal courts on the mainland. So if you're in a city, you have your city court, you have your municipal court.
Right.
Sometimes they have district courts that do misdemeanors. So there became this gentle balance between misdemeanor and felony, and what are we going to do, and all of that stuff. And the idea was is that, well, there's too many misdemeanor people in jail. Let's have citation release, which I favor citation release. I have no opposition to that. Then we get into arguments about failure to appear. I'll tell you something. I have never won an argument on failure to appear. We have a 73% failure to appear rate on misdemeanor cases that originate in Waikiki. 73% documented. 73. It doesn't matter. They don't care about failure to appear. When I was a pretrial worker, we had a 5% allowable failure to appear. 5% allowable.
Oh my God.
Yeah. Well, if you can keep it with, as a bondsman, if you have a 0.5%, you're out of business.
Right.
You can't afford a 0.5%. If you do the math, and I bailed out at least 25,000 people in my career, and I've released at least 2,000 on pretrial release via my signature authority and or recommended to the court. But the point here is we need balance and we need fairness. What's it going to be? Right now in Hawaii, just so you know, we have a bill, House Bill 2413. It's going to be heard by the Senate today, I think, about 11 o'clock, where they want to just release every single misdemeanor, no matter what, and most Class C felons, no matter what.
Yeah, what is a Class C felon in Hawaii?
That's a good question. We got 3 of them. We got
right.
A, B,
I saw
and C.
C, which is, that's awfully small classifications anymore. Even Kansas used to have A through D on their felonies, and now we have levels 1 through 10, and we've expanded that, parsing it out a whole lot more.
Right. I don't really know the answer to that. A low level, but there's a lot of crimes in there that retail merchants in Hawaii they're just incensed with this. People can walk into a store and pick up $1,000 worth of stuff and walk out and not get arrested. I mean, give me a break. I mean, look at Portland and Seattle, where the doors are closed on these, and nobody seems to think that, could it have anything to do with pretrial justice or not? And they don't want to build a new jail. Let's spend it on education instead, which I favor spending on education. So there is a balance there. But to sort of home in on what's happening in Hawaii, the district court here in the state of Hawaii will not hold a misdemeanor client more than 72 hours. 72 hours is the maximum you can be held. That means you're arrested. That counts as a day.
Right.
You go to court. That counts as a day.
Right.
99%. We've got like 23 people to 46, depending on whose number you want to believe, out at our jail out of 20,000 annual arrests. 20,000 is what the HPD says. And we've got, depending on who you want to believe, less than 100 for sure. So what do we, the people, do about these things? We've got this crime, and they say, if it's violent crime, then let's hold them. Let's hold them. Let's carve it out. If it's violent, let's carve it out. Let's hold them. We have a doctor over here, if you can believe it. He's been in jail for a year. They said he tried to push his wife off the Polly Lookout and tried to stab her with those needles that the doctors have to help people. Syringe. But it just, to me, we need to argue the issues of balance and fairness. We need to stick to pretrial justice. We need to let judges decide. That's my point of today. Courts need to decide what to do. We can't have the legislative people interfering, butting in, micromanaging. We need to let judges, we elect them or we appoint them. In Hawaii, they're appointed.
Right.
10-year term.
how often, and that's a whole nother issue as well, is then you have what is judicial accountability in an appointment, and how do you remove them? I mean, Kansas is a mix. About half of our counties, they elect their judges, and about half are what they call the merit selection, and then they have a retention election. But of all the judges that are subject to a retention election, none of them ever don't get retained. You know, in fact, if you look at that from a nationwide standpoint, Illinois has the highest level of judges that are not retained. Basically, I think I read something that's like 75% of all the judges on merit selection, they're not retained in retention elections, all come out of the state of Illinois. Not because they're corrupt or they're bad or anything, but because Illinois has a much higher threshold. They've raised the threshold to, I think it's 62% or 60. It's either 60 or 65%. You have to get that level of retention on your votes since you're not running against anyone. And so routinely they would, get 70, 80% retention rates. Illinois raised that level up, and so then they're actually cycling through. So you can actually make a campaign saying, this judge is not doing what he's supposed to do. He's a poor judge. He's sleeping with his secretary. He's making bad decisions. He let this person go. We don't think that's the person we want on the bench. And so the vast majority of all retained judges that get turned out, they're almost all from Illinois, and no one else is willing to raise the level. Whereas elected judges, if you get way off base from the population, or you get overturned by the Court of Appeals multiple times, then you have somebody else that steps up and says, yeah, I think I'd be a better judge than you. Let's have an issue over whether or not you should still be a judge or I should be the judge. Again, the argument against that is always, nobody really knows who they're voting for with judges. Well, how many people know who they're voting for with politicians, period, until they get in there? Anyway, you also brought up another issue of denying a bail. Does the Hawaii Constitution allow denial of bail in non-capital cases? Yes. So it does. Yes. The Constitution doesn't have that absolute guarantee.
Well, it's open to interpretation. You could read the Constitution, but then it references 804-1, the definition of bail. The essence of it is it leans toward release.
Right.
It's only one line in there. It's not the traditional. I've read it over and over and over. And I put it in all of my testimony. I just wrote a letter to the governor. I wrote it down, but we have the statutory scheme. We've got, in my view, balance and fairness among the judges. We're very lucky in Hawaii. I don't think I've ever met a bad judge in Hawaii. Everybody wants to, probably do the right thing, I think. We just don't know how. We look to the mainland, that's you guys, to try to help us out so that we can see the goofs and the mistakes you've made, or what works, where does it work? Well, I know for a fact Portland didn't work.
Right.
Because they don't talk about it, but that 10% that you give that court in Portland, when that guy's convicted, they keep that money. They don't give it back. Nobody talks about that. Nobody says, oh, you pay that to the public defender's office. Nobody says you pay that over. They don't talk about that. They've turned the cash thing. They don't talk about Kentucky pretrial release where they set the cash. We had the Kentucky people and the R Street people fly to Hawaii and put on a seminar to tell how great it is over there, only to find out that they set the cash bail. And I thought, what are you guys doing, And then they only pay the pretrial worker $37,000 a year. Don't quote me on that. That's what I heard. It's on tape. Go listen to it yourself on the Hawaii State. Well, in Hawaii, you're not going to hire anybody for less. We pay our policemen. There's not a policeman out there, even a recruit, that's not making $150 a year with his overtime. So I don't know, this balance and fairness. What are you going to do? Where does it go? Where is it taking us? So we're looking right now for where is the success? What has worked well anywhere? What works in Florida? What works in Indiana? What works in Texas? Where's the balance? Where's the fairness? Where's the equity? And it's sort of boiling down to one thing. The one thing is this: it's a misunderstanding. Right now, the chatter is he's innocent. He shouldn't have 1 day in jail because he's not been convicted. He's innocent.
Right.
They don't want to tell you that, could it be that he's accused? Don't you think that the prosecutor and the police and several other people, maybe a judge, has looked at this situation? And don't you know that our conviction rate is very high? There's a possibility that, this person is somewhere needed to be looked after, either by intake service center, a leg bracelet, stay at home, maybe his mom and dad. I have an airline pilot right now. He gets in a fight with the wife. He sends her a text, and the judge throws him back in jail, makes him sit there for 2 months. Then he can't get out. He's got to go home. He's got to stay at home. So he's got a bail, subject to the condition that he stays at home.
Can't fly.
No, where's, I don't know where it's going, which is why I look to meetings like this. What can we, the people, do to argue these issues to improve pretrial justice? Where's the line in the sand? That's what I want to know.
Well, I'm not a fan.
Help me out.
I'm not a fan of the presumption of innocence argument. The argument I've always made on that is the presumption of innocence is why we have bail. Okay, if we didn't have the presumption of innocence, there'd be no reason to offer people bail. So the presumption of innocence is why we have bail. It's not a reason to basically be required to let everyone go, because take that to its logical conclusion. If the logical conclusion is that you're presumed innocent and so we cannot hold you, that means everybody. That person that's charged with murder, they're just as presumed innocent as that person that's charged with shoplifting.
Exactly.
So if that's your argument, then you cannot hold anyone on a pretrial basis. That's clearly not the law. That's clearly not good policy. There's no reason that that's the case. Well, then go, well, but only in these cases. The cases that I've looked at here, this one person that's my anecdotal case. Well, that guy, he should have gotten out, but not this other guy. And I mean, everybody with their Facebook law degrees, you look and go, well, how was this guy ever out in the first place? Well, are you the same person that was arguing 10 minutes ago that this other person was presumed innocent, and why was he being held? And so that I'm worked up about this because I just was in the legislature and had this back and forth argument with somebody arguing that I was impugning the presumption of innocence by saying the presumption of innocence is a trial standard. Probable cause is the standard we use to determine whether or not we can hold someone pre-trial. Those are two different evidentiary standards, and the Supreme Court agrees with that. But you sit there and go, well, you're impugning the presumption of innocence. No, I'm not. But that was a back and forth, and it's like you can't make that argument and then have not run into a logical fallacy as the crimes get more serious. So again,
exactly.
I'm not a fan of that particular argument, but it's the one that everybody uses, and it's a simple thing. Well, our Constitution says you're presumed innocent. Sort of, but not explicitly. So you have to go through all these different things, all the things that the Constitution does. Due process, bail itself. Those are the things that we look to and say, well, this is why the Constitution implies that you're presumed innocent, and so we've adopted that as our standard. But bail is one of the things that supports the presumption of innocence, not against it.
Exactly.
So.
Exactly. So where do we go? How do we I don't know how many emails I have out there, but I send a lot of emails, and I see who reads them, and I see who doesn't read them, and I see who responds. And out of 100 emails, I might get 1 or 2 responses.
Well, true.
I mean, give me a break. I don't know where they're getting the money, but from what I read online, there's large sums of money being spent. And I know for a fact that certain agendas are being adhered to and certain protocols, and they have a very smart idea how to do it. They get very smart people that know how to write. They know how to speak. They're not charged full of emotion like I am, because I'm on the front line. I get emotional about it because I'm thinking about the poor guy I bailed out last night or the day before who was accused of something, and I know he didn't do it. The university professor, the electrician, the lawyer, you just don't know what's going to happen. And then you've got every other class of crime out there. And I was in court yesterday, and the public defender tells the judge, "Oh, he didn't hurt anybody, Judge. If you let him go, he can give you an address within 72 hours as to where he's going to be." So in the old days when I was a pretrial worker, rule number one was you had to have an address, or we're not talking to you. How long have you been in the county? Right. Then you had to verify it with somebody. We had to have a phone number. So if you didn't know somebody's phone number to call to get verified, you're not going to get out. We're going to have another method, and then we're going to have to speed up the case. My argument has been speed up the cases. I had a case the other day. The guy's been out for 5 years. 5 years. Give me a break. How do you drag a case out 5 years? I mean, come on. And lots of my cases last 2 or 3 years. I've got 3 substantial, because I have the check-in program. People check in with me. I try to coach them up, try to make sure that they stay focused and things of that nature. So I pay a great deal of attention to length of time out on bond and the long delayed justice. So my pitch, for what it's worth, is let's speed it up. If you want to spend money, let's just speed this stuff up. And speed up the sentencing. That's another problem. I mean, 5 years probation? I mean, come on. 6 months is plenty in a lot of circumstance. I mean, tap on the wrist, people, third time, fourth time, fifth time, maybe you drag it out. But sentencing guidelines is another problem. This whole idea of lawyers. When I first started as a bondsman, I kept a lot of statistics, because I wanted to know, was Hawaii like the mainland or not? Right. Did the people have a 10% failure to appear, 15% failure to appear? And then I wanted to know, can you find them or not? Well, everybody said, well, you're on an island. How hard could they be to find? Let me tell you something. They're pretty hard to find when you got the relatives hiding them out. You can't find them. If they don't want to willingly come in, you're not going to find them any easier than you're going to find them in California or Missouri or Florida or anyway. My point is the failure to appear rates were substantially similar. So what do we do about failure to appear? Do we worry about that or not? I don't know. I don't know. We need to move the argument forward. Somehow we need to help those people that want to improve the system, and we just need to keep talking it up like we're doing today. I think that's the answer.
Well, Hawaii did, and I was doing a little bit of research on this, but Hawaii did a pretrial justice task force back in 2018-19. And that was all the rage back at the time, because we had one in Kansas as well. The equal justice people were suing everybody and their dog, and so everybody needed to look at trying to figure out what the response to that was. Now, fortunately, we've reached the stage now that the higher level courts have all rejected those theories, like unaffordable bail is unconstitutional. That's not a thing. But that was the argument that was being made at the time. And so one of the goals of that Hawaii task force, and I was reading over this, was to examine and, as needed, recommend legislation and revisions to criminal pretrial practice and procedures to increase public safety while maximizing pretrial release of those who do not pose a danger or flight risk. Now, it strikes me that those are contradictory goals. It's sort of like the Fed trying to maximize employment and limit inflation. And so you can maximize employment by dropping interest rates to nothing, and man, you'll get an explosion in people being hired and full employment's there. But inflation will go out of control. So how do you sit there and say, well, we're going to increase public safety while letting people go? If the more people you lock up, the more safe you are publicly. The more people you let go, the more crime you're going to get. So how can you maximize pretrial release while at the same time increasing public safety?
Well,
go ahead.
Let me comment on that. I was involved in the HCR 134 task force. That 250-page document, you'll notice that there's at least 27 pages written by yours truly. There's also a lot of very valuable information in there from PBUS, because Beth Chapman was president at the time, and she assisted and cooperated. And fortunately for the state of Hawaii, we had 2 of the smartest people involved. We had Magistrate Judge Ram Trader, and we had Judge Shirley Kawamura. Probably two of the smartest, most experienced people. But then you had a whole gaggle of inexperienced people that they had to fight with, trying to say, oh, well, we don't need this, we don't need that, blah, blah, blah. Anyway, sort of the end of the story was that they came up with Act 179 of 2019. Okay. And I got one thing in there, my claim to fame: daily bail. Daily bail, daily bail. Because in Hawaii, only the court or the agency setting the bail. This is a concept now.
Right.
The court sets bail. The police set bail. But where's most of the people after court? They're at the Department of Corrections. They don't set bail. So you have to go to the court to file the bail. Then you got to run around and take it back, the receipt, to where the person is at. They could be sitting in the weekend, $10 bail, 72 hours extra, because the place where they're at, they can't reach in their pocket and bail themselves out on $10. Sure. There's no pretrial release, blah, blah, blah. So I got daily bail. The court had to devise a system for daily bail, whereas in the past they've tried various schemes and circumstance. Can the police do it for the court? Well, the police in Hawaii are city and county. Guess what? City and county doesn't want to help the state. Well, sheriff. Well, I don't know. There was a lot of problems with the sheriff. Anyway, the end of the story is, if you're at the police department, you can generally speak and bail out quick enough. If you punt it over to the corrections, you could be stuck. And that HCR 134 task force, it just exploded everything. But if you read it thoroughly and completely, you'll see that it was written in such a way that it was trying to promote balance and fairness. But it said, give us a chance. The court said, give us a chance. Would you just give us a chance to just sort out a few of these ideas, and let's see if this works? Let's test this, test that. And the court they bent over backwards to release. Because right away we have COVID. COVID pops up. Oh, well, COVID, you can't have anybody in jail. You're going to kill them. And, we closed the schools down. Everybody's taking a shot. High level of controversy. It was a big deal. And it's still a big deal. So we have a bill at the legislature right now that says, oh, by the way, pursuant to Act 134, are we going to have daily bail or not? So that's going to pass this session because they had what's called the Penal Code Review. Every 10 years, Hawaii has what's called Penal Code Review. And they get 60 of the people that they think know enough about it to have a Penal Code Review. So because it's open to members of the public, I got myself involved and I sat on the Penal Code Review, and I got assigned to the bail committee. The bail committee. Guess what the bail committee wanted to talk about? Nothing except what the ACLU wanted. Right. They didn't want to talk about one thing that a bondsman wanted to talk about, and I submitted two bills, Senate Bill 2279, Senate Bill 2280. Well, there just wasn't time to talk about it, but there was time to talk about daily bail. So I got the one thing inserted in there. We got the daily bail, but we need, in Hawaii, if a person misses court, you can't fix it. That's the problem. And, there's a lot of goofs. Most courts have a magistrate or they have jurisdiction. So where if a legitimate person makes a goof, they're not going to charge him $1,500 to go fix the goof. And they're not going to make him go get himself booked into jail and spend the night in jail to appear to go say, I'm sorry, Judge, the bus was caught in traffic yesterday. I'm sorry I was late. I mean, where does that happen? Nowhere.
Well, does the court not have the ability to, because we've seen most municipal courts in our area have what they refer to just loosely as an amnesty docket, that you can, once a week, you can walk in if you missed court and get it straight out, because they have such a high failure to appear rate.
I'm learning amnesty docket. We need an amnesty docket in Hawaii. Thank you, sir. Thank you.
There's also
amnesty docket.
Generally, a lot of the courts will allow you to come in either with your attorney. It also depends on what sort of court, what appearance you miss court for. If you miss court for a scheduling conference, they're going to treat it a whole lot different than if you miss court for your jury trial, where all the witnesses and everybody, we impaneled an entire jury and then you didn't show up for that. That's a whole lot another story from, well, you missed court for what was going to be what we refer to as a scheduling conference or a status conference, that we're going to continue your case over anyway. We're just calling you here to make sure your case is still moving along. We don't turn around and set this for 6 months down the road. We'll set it next month so the judge can tell the lawyers, get this case moving. Either get to a plea, get to a trial, tell me what we're doing here. But if you've missed one of those court appearances, normally you can get back in front of the judge with your lawyer. Some judges will have a specific time. You can come in Wednesdays at 11 to one particular judge and say, mea culpa, I'm really sorry. I had car problems, I had whatever. And the judge may make you go take a UA. If you test positive, well, then you may get your bond revoked, and they may go ahead and execute the warrant. Or at that point in time, the judge may recall the warrant, reinstate the old bond, and continue on your way. But that doesn't have to be a statutory change. That can just be a change in the way that the court manages its docket. And I know that Chicago, for instance, they'd gone completely overboard on that, and they had rescheduling kiosk in the courthouse. So you could basically just ignore court and then just make sure you checked in at some point in time. If you managed to avoid getting arrested on the warrant, go to the kiosk in the courthouse, press a few buttons, and they would cancel your warrant and give you a court date. That might be taking it out of the judge's hands a little bit too much. But there's ways to do it. But I think what you're getting at there is your bill 2413 that's up there inserts this language about willful flight. And so I'm reading the definition in the bill. It says, for purposes of this section, willful flight means intentional conduct undertaken with the purpose of thwarting the judicial process to avoid prosecution, as evidenced by recurring or pattern conduct to evade prosecution, or by a failure to take affirmative steps to communicate regarding or remedy missed court dates. Willful flight does not include isolated instances of non-appearance in court. So basically, they're building into statute that it's okay to miss court. If that passes, and they basically say that the court can only make you post a bond if they find that you're a risk of willful flight, not a risk that you'll just ignore it and maybe stumble back in now and then. But that's been one of the things the courts have always looked at, is what's the likelihood that you're going to show up for court. Now they're raising this bar to it. We have to show, or the state has to show, that you're likely to willfully miss court, not just accidentally. I don't know how you do that. It strikes me that language there basically forgives failure to appear.
Well, I think this is a two-part answer. We've got the old way and we've got the new way. So the old way was fair, balanced, just. Judges could do whatever they wanted.
Right.
Well, I don't remember exactly when, but let's just say 3 years ago, the prosecutor in Honolulu decided that he didn't want to be involved in bail other than one thing. He would forfeit it. After it's forfeited, they punt. It goes to the Attorney General Civil Collection Division. And they put a bite on that bond. They want that money. And there's no fans or buts about it. They just say he missed court. Just give me the money. We don't care if it was a goof. We don't care if you want to reinstate it. It's just too bad. We want the money. So they have Civil Collection Division, and it's changed the complexion of the game in Hawaii. They just want the money. And other states have probably been through this, where maybe they give the money to the school board, or maybe there's a legitimate purpose. We tried to get bail bond fees so that you file a bail, they could get some money.
Just
$10 or
we're talking
$20.
about the same thing though, because we use different things. What we have is forfeiture is what occurs when someone misses court, and then we have a judgment on bond when that forfeiture is basically then converted from just a declared forfeiture to an enforceable judgment. And it struck me when I was looking over some of the Hawaii statutes, says that the language you have for forfeiture is actually that judgment. So basically you miss court at some point in time over here, and some period of time, 90 days or whatever passes, and then that becomes an enforceable judgment. So are we talking about then it goes to the Attorney General for collection after that 90-day period when that forfeiture is a judgment, or are we talking they're pursuing trying to collect that declared forfeiture when the person misses court?
They're pursuing trying to collect forfeiture the moment they miss court, even though there's a 30-day window where you can file. There's a 30-day alleged window where go hire a lawyer, contact the Attorney General, file a motion, and try to sort it out. And then you have an argument. And in the meantime, the poor defendant's got a bench warrant out for him.
Okay.
I mean, it's backward. It's just, we don't know what to do about it. We're trying to explain to the people in authority. None of the judges want to do this. The judges know what's going on, but you've got a very different idea now. It's like attack mode. They're attacking the bonds person, and there's really no rhyme or reason for it. I think it's because they think that the surety insurer has the money grows on a tree. It's not an attack on the bondsman. They want the money. It's like, I had a federal court judge tell me, Jim, isn't bail like a life insurance policy, a term life insurance? If the person misses court, you just $100,000 comes off hand it over. I mean, it's education. That's what I want to promote here as we go down this road. Education. We need to educate. All politics is local. We need to keep talking it up. These people that wrote HCR 134, they're very smart people. They know what to do. We have very smart legislators. They know what to do. The judges know what to do. We have very competent court staff. They know what to do. But it's slow. It's very, very slow. And
well, I did look at the HCR 135 on that, and there were, and looked at all the recommendations, because I'd gone through the same thing in Kansas, because they made a bunch of recommendations, and some of them are very similar. But there were a couple of them that it looks like this new bill that's there is completely ignoring. There was recommendation 13, which says to integrate victims' rights by considering a victim's concerns when making pretrial release recommendations. So if you're basically saying on class C nonviolent felonies and everything below that, you shall let people go. Are they taking into account the victim's feelings on that? That was the issue in Illinois, that they completely ignored the victim's Bill of Rights.
Yeah. Ignore. We copying. We're ignoring.
And then in recommendation 17, it was to require monetary bail to be set in reasonable amounts based upon all available information, including information concerning the defendant's financial circumstances. That's basically an argument for reasonableness. And it strikes me that this latest bill is as a recommendation for unreasonableness, just a blanket unreasonable policy. We're not going to be separating this out unless you can prove these things. There's some exceptions there, but it seems like it would be very difficult for the court to go through and make those exceptions to then require bail on anything under a Class C nonviolent felony. Maybe you were reading that.
No, I think the direction Hawaii is going is very clear. It's solely about the defendant. It doesn't matter if he has residence, he doesn't have a job. It's about the defendant, period. It doesn't matter that he doesn't have a surety. They don't care. They just don't care. I don't know what to do about that. In the old days, you had to have a third party. This whole notion of a one-on-one with the court, it just doesn't work. You have to have somebody see to it that this person is helped, to guide the direction. The lawyers can't do everything. Just to jump back to something about the public defenders versus private lawyers. When I first started, 70% of my clients, 7-0, had private lawyers. 70%. You know how many people have private lawyers in Hawaii today?
What, 10% maybe?
1%.
1%? Really?
How does it go from 70% to 1%? How is that even possible? It's because the public defenders take all the cases for free.
Right.
That's the reason. They take it for free. So unless you want to pay a private guy, you're not going to
qualify for that.
You're supposed to qualify, but what happened to 70 versus 1? Actually, I should speak on this issue. In addition to being a pretrial release worker, guess what I did for 2 years? I interviewed people for public defender services. I did a financial statement. I submitted that to the court. The judge would look at that and he would say, is this true? You don't have any money? Or is this true? You have a job? And the judge would make a judicial determination as to whether that individual, based on my interview, my personal interview, qualified or not. Now it's like automatic. And I can't
rubber stamp.
Speak to that, but it's a rubber stamp. And the data is there. The statistics are there. I know what my data was, and I know what it is now. What do we do?
Yeah, I don't know. I do want to talk about the opponents here because you brought this up, and this was not a group that I was particularly familiar with before I'd seen something else on that. Was obviously the ACLU, and you mentioned when we were talking before the interview started that you were a longtime member of the ACLU, and that there was a time back in the day when the ACLU supported bail. I mean, they were one of the amici on the Salerno case that basically challenging the Bail Reform Act in 1984, saying, hey, you cannot take away the right to bail. The Constitution guarantees the right to bail. The Supreme Court, decided that having no bail at all was not excessive bail. It's like, okay, that's anyway, that was parsing the language. They got the result that they wanted on it. And that language is what they use against us now, because they'll equate being held in lieu of bail with pretrial detention. And so but they're not the same thing, but they'll use that language from the pretrial detention case and say, well, if you've got a bail that you can't post, you're functionally the same thing as preventively detained. No, you're not. I mean, functionally, you might be sitting in jail, but you're being held in lieu of a bail. And if you look at the dissent in Salerno, they basically wanted to throw the case out, the dissent did, because one of the people had already posted bond and so didn't apply anymore. He had a bond set. Anyway, I don't want to get too worked on that. I want to talk about R Street because I wasn't really familiar with them. Looks like they're a nationwide group, kind of a think tank. They claim to be center right. And it's just strange to have somebody that's in theory center right who's then advocating for wholesale pretrial release. What was your experience with R Street, and what is your understanding of who they actually are?
I've had a great experience with R Street.
Right.
It's almost unbelievable. I felt like I was back in pretrial release in 1974. The R Street person flew out here to Hawaii with the Kentucky person, and they put on a big show, and it's all recorded. You can see me sitting in the gallery with my little puppy, Prince Storm, and you can listen to what they have to say and what they brought to the table. And I hemmed and hawed, and I didn't say anything for a long time. And then they had nerve to write a op-ed, and it came across my desk, and the op-ed was, I just couldn't believe the op-ed. So, of course, I needed to respond to the op-ed. I responded to the op-ed. And remember I told you out of 100 letters, I got one response? Guess who responded? The head person of the R Street responded in the most eloquent of manner, just the most eloquent of manner. And it's my impression that they really believe what they're doing is fair and just and equitable. And they think they're improving but they never met anybody like me who would draw their attention to certain issues. And she took great pains with the issues. So, of course, I responded to that, and I think it's over. I don't think I'll hear from them again. But my experience with them is and was and still is, I smile when I think about that lady. I don't want to mention any names, but I think that it's a valuable tool. I think that eventually they're going to see the light. I think that they're open to communication. I think that they will at least attempt to argue the issue, which is more than the ACLU of Hawaii has ever done with me. Let me tell you that right now.
Right.
I got all my letters out to the ACLU. You know how many I've gotten in return?
Nothing.
None.
They're fully left-wing captured. They're not the ACLU.
Wait a second now. It doesn't matter who the capture is here. Let me tell you something. I know the legislative process. I don't want to sound, emotional here, but the legislators want the people to argue the issues. They want the yin and the yang to argue the issues and then come to the legislature with a solution. That's what legislators expect in the state of Hawaii, and I'm sure they expect that elsewhere. And when those legislators found out that those people refused to communicate, I had 7 meetings set up. 7. And these are smart people. Yale, Harvard, private school, blah, blah, blah. I mean, set up the meeting, cancel the meeting. Set up the meeting, cancel the meeting. Oh, I'm on vacation. Oh, I can't make it. Blah, blah, blah. Or they just ignore you.
Right.
That's a problem. No, that's a problem.
Right.
That's a problem. Our street is different. Our street is different. And I think that lady in Kentucky that runs that Kentucky thing is different too. I have a high hope to communicate with her so that maybe we can get some balance and fairness here, so that maybe we can get both sides of the issue. And because I don't think that the ACLU, if they went to court, if they would come and look at one of my files so they could see what pretrial justice really is, I can't imagine that they wouldn't want to at least talk about it. They at least talk about it. Now they don't want to talk. They promote their agenda. And I don't really know what to, and I'm not a member of the ACLU. I'm a supporter.
Okay.
I'm a supporter.
Okay.
I have a long-time supporter because even though they passed legislation in Hawaii, signature bond, no collateral bond. And they just thought, oh, that was just the greatest gift of the people of Hawaii. We give the judges a no collateral bond. Guess what the judges wanted to do? They want pretrial release. They want to have a supervisor. So They refer to the intake service center because they know better. The person that gets in jail, they need help. They need public defender help. They need coaching. They need a phone call. They say, oh, well, we'll just send them a text. Come on, give me a break. You can't, some of these people sending them a text, it's not effective means of communication.
But you would think that the ACLU, the American Civil Liberties Union, would object to people who are charged. I mean, their same argument that they're presumed innocent, they're not convicted of anything. You'd think that they would object to people that are just charged and not convicted being functionally placed on probation, because that's what pretrial services is.
Correct.
Why aren't you making that argument? The argument only seems to be, well, we don't want them to have to pay a bail bondsman or put up any sort of assurance that they'll be back. We're fine with them having to go spend $100 a month taking drug testing or $500 a month having an ankle bracelet. That's all good. But, that just strikes me that you've lost your way. If you're, I can see, okay, we want to argue against, if you want to argue against people being held pretrial, that's fine. But you have just as valid an argument against people being functionally placed on probation before they've been convicted. And the ACLU doesn't make that argument. The most argument I've seen them make on that is, well, the state should pay for those monitoring costs. Why should they be being monitored at all if your argument is that they're presumed innocent?
Right. And actually that's in the bill that's probably going to pass with the daily bail. They're going to say that the Department of Corrections has to pay for those monitors. Well, Department of Corrections doesn't want to pay for the monitors. They have enough problems paying the for whatever they've got already. So they put a thing in there. Well, if you give us the money, then we'll pay for it.
Sure. Yeah. And there's another unfunded mandate because people don't seem to understand monitoring costs. I mean, even if you're handling it all in-house and you're not including anything else, you still have to pay the company that does the monitoring.
Yes.
$5-6 a day. And by the time you then factor your others, and normally when you have a electronic monitoring company, they're charging $15 a day or more for house arrest type monitoring is set up. It's like that gets really expensive really fast. I mean, you're looking at $500 a month. That's $6,000 a year to put someone on that sort of monitoring. And then you complain that they had to post a $250 bail. You've eaten through that in a hurry. Let me get a little cynical here. I know we're running out of time here, but as far as R Street, I saw that R Street got a whole bunch of funding, and I don't know if it's recent funding, from the MacArthur Foundation and I think from Vera. And
she told me. She had to tell me where they got the funding from, and I thought she told the truth. I was happy they told me the truth.
But generally, you're not going to have a center-right group take a position on we want to let everybody go unless they've gotten funding from some group that's pushing that, like MacArthur, like Vera. And so now we've gotten this money, and suddenly now we're making this argument. So I don't know that any amount of arguing with them or trying to persuade them is going to offset, $1 million worth of donations, that they got to keep their program running. So
I don't think that's my point. That's not. I agree with everything you just said. I think you're completely 100% correct. My point is, we can learn.
Right.
It's very difficult to learn what the other side is thinking or doing. It's not that easy. If you don't have the back and forth, it's like, you know how long it takes to prepare testimony? If you don't start a year and a half in advance, it's like sharpening that blade. Your blade is dull. If you're not reading the other testimony and you're not sharpening your blade at every subsequent set of testimony, you're going to get nowhere. These people at R Street are going to help the bail bond industry because they'll at least talk to Jim Lindblad. I got a fact on that. Right. So I think you could say, well, I understand you spoke with Jim Lindblad. Here's the article that you can read, the op-ed that she wrote.
No, I got it.
You could say something kind and gentle to her and she'll respond, and maybe that'll help you sharpen your blade for balance and fairness, which is what we all want. Equity, that's what we want.
The article, though, was that Hawaii has an opportunity to fix its broken bail system. That was the article, right?
Yes.
Okay, right. And so one of the points in there was, well, they made a whole bunch of changes 5 years ago. It's like, and there's still just as many people in jail. Well, that's not a broken bail system. That's whatever these recommendations that you made and you pushed, maybe not her specifically, but the bail reform people pushed. If the goal was to balance public safety and maximizing release, well, then you probably have that equilibrium to start with. What you're saying is, well, forget that public safety noise. We didn't release enough people. That's their version of the broken bail system.
Right. Well, she got that part wrong, though. That's the problem. And I didn't stand her corrected. But she knows, and everybody knows in Hawaii, that we got plenty of room in our jail right now. There's last Monday, there was 45 open spots.
Yeah.
In 2019, there was 245 over. So we got a 300 reduction in 6 years. It's no longer a critical matter. So the fact that she said it was the same, it demonstrates that they don't get it right, or that they believe the wrong data, or they interpret the data that they're handed incorrectly. And you take a deep dive down into it, and then you find out, I'm sure that if she's not going to be writing another letter like she wrote like that again. And because she knows she got it wrong.
Right.
What's she going to do? Write another letter, say, oh, I'm sorry, I made a goof? No, she's not going to do that. But she's not going to write another terrible letter like that. She just won't do it. That's where I see hope for R Street.
I think
they'll help us. Yeah, I have hope. And I think that she'll see the difference between what the ACLU agenda is, and she'll see that they have an agenda. And some of these smart people they have a heart. They want to assist and cooperate. They want to have balance and fairness. And I think R Street has that potential for balance and fairness. But we're not going to get the first base if we hammer them and hammer them and hammer them and tell them negativities. We have to go in to fully argue the issues. That's where I started when we started this conversation. We need to fully argue the issues. That's what needs to happen. That's my message for today. And I think that if we fully argue these issues, we'll make a giant step. And that's where programs like this work,
Well,
in my view.
and let's hope. I mean, you also have a slightly different situation there in that you have 21 out of 25 senators in the Hawaii Senate are Democrats. I mean, that is a super majority. Not just so some of the arguments we could make here in Kansas, focusing on the public safety aspect of it, and we can sort of ignore the releasing the fitness part because we're coming a Republican supermajority is looking at us. We need control over crime, and so they're going to be a lot more receptive to that. And so if you're making this a similar argument, it's not going to fall on the same ears in Hawaii that it might fall here as well. And we're starting to see that separation in the states is so we need to be able to make the argument to both sides. And I think, Jeff Clayton back in the day was like, well, are you Republican or Democrat? Well, it kind of depends on the argument that we're making here. If we're arguing for, we need to have civil liberties and people need to have a right to bail, well, then we're making a Democratic argument. If we're arguing public safety, and then we're making a Republican argument. But bail is sort of in the middle of those things. I mean, we're balancing two competing interests. And so we don't want to go too far one side or the other when we're making those arguments, but we still need to be able to resonate with the people that we're talking to. So anyway.
Well, we've got the federal government, which is another problem. Whoever you want to believe, whether it's 70% detention rate, 33% detention rate, the detention rate at the federal level is much higher than any state court.
They've changed the definition on that. It's still 70% detention rate, but what they're doing is they're saying that 35 of half of those people have consented to the detention. And all that means is they've waived a detention hearing.
Right.
Nobody's consenting to it, but they've parsed that off between, well, we've ordered a detention order and you've consented by waiving that. So we're not saying we're holding 72%. We're only holding the ones we have the detention hearing on because the others have already agreed for their own good to be detained. That's just a definitional lie, for lack of a better term, that they're using to try and get away from this argument that we and other people have been making that you're holding too many people in custody. They've just changed the definition of what that means.
Right.
So. Anyway.
Well, my point is, I think we have a long way to go, but I think we're well positioned. I think that until your son or your daughter or your wife has a problem with the police, or until you yourself get grabbed and your liberty is taken away from you, I mean, just think when the policeman stops you, there he is with his gun. He's looking at you like under suspicion, like, what are you doing? And then he puts you in the handcuff, or he puts you in the car, and he wants to talk to you and bully you around, and because he's approaching the normal person from the lowest common denominator person. After you care, caution, whatever you want to call it, and it's a hard situation for all concerned. Portland, Oregon. When I left Portland, you had to have a 4-year degree to be a policeman. They felt that would help police if you had a 4-year degree. Some people, you got to be 18, I think, to be a policeman. Well, basic training. Military people, in my view, tend to be better policemen. They've got a certain training, and I don't know where it comes from. My father was military, and he came off the farm in Minnesota, and he had that training, and he rose to a very high rank. He could fly a 4-engine airplane. I mean, that's a pretty big deal. So how do we, the people, help, assist, cooperate, move the argument forward? It's by doing this, talking about it. That's what I think.
Well, Jim, I'll let you get back to the beach. It looks like a beautiful background there. Hopefully the real background is just as pretty as that. I've never actually been to Hawaii. Hopefully we can get out there at some point in time. But before the crime takes over
extending invitation. Elks Club in Waikiki.
Okay.
I'm a longtime member. You have standing invitation. You have to come here. I just love to show off. I just love to talk story. We call it in Hawaii. Talk story.
Well,
Talk about bail.
My wife away from her horses. Maybe we can get out there.
Wow. 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 Yes. Thank you. Thank you. Thank you. Thank you.
Again, thank you very much for coming on. I really appreciate talking to it. Getting the perspective from there, especially from a deep blue state like that, and we don't always get that when we're talking about stuff. And so it's nice to hear. It's nice to hear that you're fighting the fight as best you can. And hopefully we can keep things going. You hate for the general public to suffer through this and then have to come back and does it roll back to more bail, or does it roll back to more preventive detention? Because that's what we've seen is, well, we want to get away from this bail. And then when that doesn't work, well, we need to lock up more people. Then let's go back to what was working before. So hopefully you can, reach a middle ground with these people.
Well, let me just add one little last thing there. We're locking people up for too long, in my view.
Yeah.
This 6 month, 8 month, a year and a half. I mean, that's a lot of time right there. Probation, lockups. I mean, this notion of you got to do 5 years, you got to do 10 years, 20 years. I mean, we're taking too long to adjudicate the cases, and we're not targeting the right aspect of pretrial justice and crime. It's because of whichever way the wind is blowing at the time. I can't really explain it, but again, if we keep talking about it, I think we'll have a resolution.
Well, sounds good.
Improvement. We want improvement.
Absolutely.
Yeah. Thank you very much.
Thanks, Jim. We would like to thank our guest, James Lindblad, for taking the time to talk with us today. Hawaii seems like a microcosm for the political divide going on the left on the criminal justice issues, especially bail. Hopefully, Hawaii will not say goodbye to common sense and start letting every criminal go on unaccountable release. The end result has always been more crime and ultimately less freedom as society cracks down on out-of-control crime. So hopefully that won't happen. But please join us on the next episode of the Bail in the Midwest podcast, where we'll continue to bring you critical information and conversations with people involved in the criminal justice system.
Join us again next time for the Bail in the Midwest podcast, hosted by Shane Rolf and executive produced by David Stuckman.